Skinner v. Oklahoma, or the right to refuse medical treatment, Cruzen v. Director, or even Ramos. But the grand jury clause, which is literally inside the Fifth Amendment, gets a shrug and a yawn and a boot. Since we found rights and freedoms and liberties and privileges and immunities outside the Constitution, then certainly those rights, freedoms, liberties, privileges, and immunities clearly and plainly enumerated inside the Constitution are good, active, and current law, if not more so. You got a right to marry because of Loving v. Virginia. It's not in the Constitution. You know what it is? The grand jury right. The grand jury right has been a part of English American jurisprudence for over 859 years. Since the founding of America, we've had the grand jury right. Prior to the founding of America, during the colonial era, we had the grand jury right. And back even to medieval England, at King Henry II's Clarendon Assize in 1166, Section 25 of the 1215 Magna Carta. King John was King Henry II's youngest son in sections 25 and 36 of the Magna Carta of 1225. Section 26 from the Magna Carta of 1225. Henceforth, there is nothing given for a writ of inquest from the person seeking an inquest of life or member, but such a writ is to be given freely and is not to be denied. So for those infamous and capital cases, in 1225 England, you could request a writ of inquest, and then they would impanel a grand jury and look at the fucking facts of the fucking case. And it was to be given freely, and it's not to be denied. For every century, this is point number 14. For every century, decade, and year, in England and America, the grand jury has been active since the 1166 Assize of Clarendon of Henry II. The roots of the grand jury pedigree, history, law, and tradition run deep. U.S. v. Dionisio, Ex parte Bain, Costello v. U.S., 1956, 1887, 1973. Masters v. Cruz, 2025, has standing and is ripe for percolation. Number 16, America's a free country. Americans are a free people. Lawful Americans ought to be allowed to present their law. Freedom is both a gift from God. It's also our national birthright. It's our legal inheritance. The administration is running away from the Constitution while John Masters sprints and marathons towards it. So let's return back to our Constitution and our beloved Bill of Rights. Let's get our feet settled in and stand firm. Grand juries protected the victims of the political prosecutions by Charles II. In 1766, grand jurors refused to indict editors of the Boston Gazette. Paul Revere was a grand juror in 1770. The Philadelphia grand jury opposed British taxes by presentment. Upholding the grand jury right will reinvigorate, revitalize, recoordinate the Constitution, the oldest active Constitution in the world today, not counting Massachusetts, and will maintain constitutionalism and preserve our political institutions as Abraham Lincoln advised us to do in an 1838 speech in Springfield, Illinois. Number 20. All of the major common law authorities, William Blackstone, Matthew Hale, Henry Day Bracton, John Fortescue, Edward Coke, all these guys, they speak on the grand jury as an important and active part of the process of the old ancient English common law. Here's Blackstone. Little inconveniences in the forms of justice are the price that all free nations must pay for their liberty in more substantial matters. 4 Blackstone Commentaries, 1769. Informations of every kind are confined by the constitutional law to misdemeanors only. 4 Blackstone Commentaries, 310. But by the law of the land, for the true sense and exposition of the words, see the statute of 37E 3 cap 8, where the words by the law of the land are rendered without due process of the law, for there it is said, though it be contained in the great charter, that no man be taken in prison or put out of his freehold without process of the law, that is, by indictment of good and lawful men, where such deeds be done in due manner, or by writ original of the common law, without being brought in to answer, but by due process of the common law, no man be put to answer without presentment before justices, or thing of record, or by due process, or by writ original, according to the old law of the land, wherein it is to be observed that this chapter is but declaratory of the old law of England. That's Edward Coke in his Institutes. The grand jury was active in the common law. So natural law protects it, the common law protects it, the constitutional law protects it, the case law protects it. How in the fuck have we ignored the grand jury right in the Fifth Amendment for such a long fucking time? Well, I guess 20 states they've upheld it, and it's in all the state constitutions. So we're just not reading our constitutions? Americans, my fellow Americans, read your state constitution, read your bills of rights. Those are the freedoms that you have been given. These are inherited. These are bequested upon you. And every generation will get the freedoms that they have the intelligence to want and the courage to take. In 1734 and 35, the grand jury protected John Peter Zenger and the freedom of the press from being indicted twice. Historically, the grand jury right has protected those accused of violating the Alien and Sedition Acts, fugitive slaves, no true bill, participants in the Boston Tea Party, and Stamp Act protesters in 1765. All the dumb shit, all those dumb laws, the grand jury protected American citizens from the dumb shit. George John Edwards from the Grand Jury Book 1906 says this: the tendency of the modern cases is to hold that it is the right of the district attorney to be present to examine the witnesses and conduct the case for the government. That it was not his right at common law was conceded by the abandonment of hearing the evidence in public when the grand jury refused to indict in Lord Shaftesbury's case. In the absence of any statute which grants this right to him, it would seem that the common law rule is still in force, and that the presence of the district attorney in the grand jury room, even for the purpose of examining witnesses, is not by reason of his right, but as a matter of grace on the part of the grand jury. Number 22. The grand jury is protected by constitution, statutes, common law, and even natural law, because it's logical that a solid guilty verdict by 24 of your neighbors is more robust than by a single autocratic, monarchical, totalitarian dictator, lowlife, disgraceful, ugly, fat, fucking piece of shit. It can logically be deduced. If 24 people say that a felony has occurred, that is more robust than that dumb motherfucking government fuck that just rubber stamps the kidnappings. The American grand jury right embodies a fundamental right backed by common natural law. The same natural law is rational man's participation in eternal law. Let me say that one again. Natural law is rational man's participation in eternal law. Natural law is rational man's participation in eternal law. An American's total bushel of freedoms is the combination, synchronization, and harmonization of our state and federal constitutions' civil liberties. An American's total bushel of freedoms is when you combine and synchronize and harmonize the bills of rights from our state and our federal constitution. And then some of the freedoms that we have, you have verbatim twin rights or similar sibling rights, which gives us the double security. That gives us the double security that Madison had detailed in Federalist number 51 on February 8th, 1788. Hence, a double security arises to the rights of the people. So when it comes to the grand jury right, most especially in those 20 states constitutions,